Right now, as you are watching this, immigration enforcement agencies are carrying out what many observers describe as one of the most intensive crackdowns on Asian immigrants in recent American history. Between January and October of 2025, ICE arrested 7,052 individuals from Asian and Pacific Islander countries. That figure is nearly 4 times higher than the corresponding period under the previous administration, when the number stood at 1,998. Among those 7,152 individuals, the vast majority, 7,069, were placed in detention, and 2,631 were ultimately removed from the country. But here is the detail that deserves your full attention. According to available reporting, approximately 69% of people taken into custody at immigration appointments had no criminal record whatsoever. They appeared for their scheduled interviews, followed every instruction, and left in a situation they never anticipated. Today, we are going to walk through 7 Asian countries whose nationals appear to be facing the most aggressive deportation enforcement in 2026. And more importantly, we are going to discuss what you and your family can do right now to protect yourselves. Please stay with us through the entire video because the 6th country on this list is one that very few people are discussing openly. Welcome back to US Updates Hub. If you are joining us for the first time, this channel delivers verified facts on immigration policy. No sensationalism, no glossing over the truth, just the information you need to safeguard your future. If this video proves helpful to you, please take a moment to subscribe, tap the bell icon for notifications, and share this with someone you care about. That one share could genuinely change the course of someone's life. Let us get into it. The first country is Bangladesh. If you are a Bangladeshi national living in the United States, the landscape has shifted beneath you in a very dramatic fashion over the past several months. Let me walk you through what has happened. On January 6, 2026, the administration added Bangladesh to the visa bond list. This means that any Bangladeshi citizen applying for a B1 or B2 visitor visa to the United States may now be required to post a bond of up to $15,000 before they even board their flight. The stated rationale centers on overstay rates. According to the DHS Fiscal Year 2024 Entry-Exit Overstay Report, Bangladesh had a B1, B2 overstay rate of approximately 5.73%, representing more than 2,200 individual overstays. But the enforcement measures did not stop at the bond requirement. On January 21, 2026, the Department of State paused all immigrant visa issuances for nationals of 75 countries, and Bangladesh was included on that list. That means family-sponsored visas, diversity visas, and employment-based immigrant visas were all frozen. If you had an interview scheduled at the United States Embassy in Dhaka, it was either canceled or postponed indefinitely. There are several reasons Bangladesh appears to be receiving heightened enforcement attention. The overstay statistics provide the administration with a publicly cited justification. Bangladesh falls under the expanded vetting framework that USCIS announced on March 30, 2026, which includes mandatory social media screening, financial history review, and consular background checks. And there are growing concerns about unauthorized employment among some Bangladeshi nationals who entered on student or visitor visas and are working without proper authorization. The administration has been utilizing workplace audits and I-9 inspections to identify and detain individuals in those situations. If you are Bangladeshi and you have any type of immigration case pending, here is what you should consider doing without delay. First, submit a Freedom of Information Act request for your complete immigration file so you can review exactly what USCIS has in your records before it comes up at any appointment. Second, retain an immigration attorney now, not later. Third, do not attend any USCIS appointment without your attorney physically present with you. The second country is Nepal. Nepal is in an extraordinarily difficult position right now, and many Nepali families in America may not fully appreciate the severity of their situation. In the summer of 2025, the Secretary of Homeland Security announced the termination of temporary protected status for Nepal. TPS had been in place for years, providing protection for thousands of Nepali nationals who could not safely return home due to the devastating earthquakes and ongoing instability in the country. That protection officially ended on August 5th, 2025. A group of affected individuals challenged the termination in court. A federal judge in the Northern District of California issued an order attempting to block the termination. However, on February 9th, 2026, the Ninth Circuit Court of Appeals reversed that order, allowing the government to move forward with the termination while the appeal continues. So as of April 2026, there is no active TPS protection in place for Nepali nationals. In practical terms, this means that every Nepali person who is relying on TPS for their work authorization and protection from removal is now in a vulnerable position. Their employment authorization documents have either expired or will expire, they cannot legally work, and they are now potentially subject to removal proceedings. The numbers are significant. Thousands of Nepali families are affected, and many of these are mixed-status households where one parent held TPS while the children are United States citizens. On top of the TPS termination, Nepal is also included on the 75-country immigrant visa pause list. So, if you were hoping to bring a family member to the United States through a family-sponsored petition, that process is frozen as well. If you are Nepali and your TPS has ended, you should explore every possible alternative pathway with your attorney. That may include asylum based on current country conditions, adjustment of status if you have a qualifying United States citizen spouse or child, or other humanitarian protections depending on your specific circumstances. Do not wait. Time is not on your side. The third country is Myanmar, also known as Burma. Myanmar represents one of the most deeply troubling situations in American immigration policy at this moment. This is a country that has been engulfed in civil conflict since the military takeover of February 2021. The military junta has conducted airstrikes against civilian populations, caused mass displacement, and carried out systematic human rights violations. By virtually any objective standard, Myanmar is one of the most dangerous countries on earth for anyone being returned there. And yet, on November 25th, 2025, DHS announced the termination of TPS for Burma, effective January 26th, 2026. Nearly 4,000 Burmese nationals living in the United States were abruptly stripped of their protection. A federal court in the Northern District of California did intervene. On January 23, 2026, just 3 days before the termination was set to take effect, the court issued a temporary order. But this legal battle is far from resolved. The government has appealed, and as of the most recent updates in March 2026, the situation remains uncertain. USCIS has issued guidance indicating that the TPS designation and related benefits have been terminated, and individuals should monitor for updated court orders. What distinguishes Myanmar from the other countries on this list is the nature of the affected population. This is not primarily a situation involving overstays or unauthorized employment. The vast majority of Burmese TPS holders entered the United States through legitimate refugee and humanitarian channels. Many belong to ethnic minorities including the Karen, Chin, Rohingya, and other communities that face documented persecution. If you are a Burmese national, it is essential that you maintain contact with organizations such as the International Refugee Assistance Project and the Asian Law Caucus. Your options may include filing a new asylum application based on changed country conditions, pursuing withholding of removal, or seeking protection under the Convention Against Torture. Do not assume that because a court issued a temporary order you are fully protected. The legal situation can shift at any time. The fourth country is Cambodia. The Cambodia situation is one of the oldest and most painful chapters in Asian American immigration history, and it appears poised to become significantly worse. Here is the background. During the Khmer Rouge genocide and the conflicts that followed in the 1970s and 1980s, hundreds of thousands of Cambodians fled to the United States as refugees. Many arrived as children. They grew up in some of the most under-resourced communities in America, places like Long Beach, Lowell, Philadelphia, and the Bronx. Some of them, as teenagers or young adults, became involved in the criminal justice system. They served their sentences, they fulfilled their obligations to society, but because they never obtained citizenship, they received final orders of removal. For decades, those removal orders sat largely unenforced. Cambodia had a repatriation agreement with the United States, but the country generally moved slowly on accepting deportees. At any given time, more than 1,700 Cambodians with final removal orders were living in the United States, many of them for 15, 20, or even 25 years, building families and contributing to their communities. That reality has changed. The current administration has aggressively pressured Cambodia to accept deportees and has begun executing those long dormant removal orders. In a particularly alarming development, some Cambodians have been removed not to Cambodia itself, but to third countries. Recent reporting documented the case of individuals who were sent to a facility in a small African nation, despite having completed their sentences years ago and having been living productive lives in the community. Legislative efforts have been introduced, including a bill called the Southeast Asian Deportation Relief Act of 2026. But given the current political dynamics, the legislation faces an extremely challenging path forward. If you are Cambodian with a final removal order, or if you know someone in that situation, it is critical to contact legal advocacy organizations immediately. There are active legal challenges underway, but you can only benefit from them if you are connected with legal counsel. The fifth country is Pakistan. Pakistan presents a unique and increasingly precarious enforcement profile. While public attention often focuses on deportation activity affecting other regions, the crackdown on Pakistani nationals has been escalating steadily. Pakistan's B1-B2 visa overstay rate stands at approximately 7.36% according to DHS reporting, which exceeds the non-visa waiver program average. The administration has used this figure to justify heightened scrutiny, and there are ongoing discussions about adding Pakistan to the visa bond list. But the enforcement extends well beyond overstays. In September 2025, DHS publicly highlighted an arrest of a Pakistani national who was taken into custody during a routine USCIS appointment in the state of Washington. The government used this case as a public example of their enforcement priorities. But the effect of publicizing such cases has been to send a deeply unsettling message to every Pakistani national with a pending USCIS appointment. Pakistan is also included on the 75-country immigrant visa pause list, which means family-based immigration from Pakistan to the United States is effectively frozen as of January 2026. Thousands of Pakistani families who have waited years, some well over a decade, for their priority dates to become current, now find themselves in a holding pattern with no projected end date. Additionally, the expanded USCIS vetting framework is particularly relevant for Pakistani applicants. The administration has implemented enhanced background check protocols that include searching social media accounts, financial records, and even messaging application activity. For communities where WhatsApp serves as the primary means of communication, this creates a significant exposure risk. If you are Pakistani, there are several steps you should seriously consider. First, conduct a thorough review of your entire social media presence with your attorney. Every post, every comment, anything that could be taken out of context or used unfavorably. Second, if you have any lapse status or unauthorized work history, consult with a lawyer before filing any new application because any submission can trigger a review that uncovers previous issues. Third, carry your emergency contact card at all times with your attorney's number, the IC detainee hotline at 866-347-2423, and the IC detainee locator at locator.ice.gov. The sixth country is Afghanistan, and this is the one that is perhaps the most difficult to discuss. Many Afghan nationals in the United States are not undocumented immigrants in any conventional sense. They are individuals who worked alongside American service members, diplomats, and intelligence personnel during the 20-year conflict in Afghanistan. They served as translators, logistics coordinators, and cultural advisors. They put their lives and their families' lives at risk in service to the United States. When the Taliban reclaimed control in August 2021, many of them were evacuated under Operation Allies Welcome and subsequently granted temporary protected status. On May 12, 2025, the termination of TPS for Afghanistan was announced. That termination became effective on July 14, 2025. Thousands of Afghan allies lost their legal protection. Human rights organizations have been vocal in their criticism of this decision. Advocacy groups that specifically work on behalf of Afghan wartime allies have warned that this directly endangers individuals whose service to the American government makes them targets for imprisonment, torture, and worse under Taliban rule. As of April 2026, Afghan nationals have no TPS protection. The immigrant visa pause affects Afghanistan, and the country is included on the expanded travel restriction list. The pathways forward have been narrowed from virtually every direction. If you are Afghan, pursuing asylum may be your strongest available option. The conditions in Afghanistan under Taliban governance provide what many legal experts consider among the most compelling bases for an asylum claim in the world right now. You need an experienced asylum attorney who understands the specific documentation requirements and evidentiary standards for Afghan cases. Organizations such as HIAS, the International Refugee Assistance Project, and advocacy groups focused on Afghan allies can help connect you with legal resources. The seventh country is China. China leads in the sheer volume of ICE arrests among Asian nationals. According to analysis of government data, Chinese nationals accounted for approximately 26% of all Asian ICE arrests between January and October 2025, roughly 1,991 individual cases. That is the highest figure among any Asian country, followed by India at 25%. But the enforcement activity directed at Chinese nationals has a fundamentally different character than what we observe with the other countries on this list. This is driven as much by geopolitical considerations as it is by immigration policy. In January 2025, China signaled its willingness to accept the return of confirmed Chinese nationals from the United States. This came in the context of broader economic negotiations and pressure. DHS subsequently conducted removal flights to China, building on a framework that began in late 2024 when the previous administration repatriated over 500 Chinese nationals and established the infrastructure for systematic deportation flights across the Pacific. Under the current administration, those flights have increased significantly. The enforcement against Chinese nationals also intersects with national security concerns. The administration has cited issues related to espionage, technology transfer, and what they describe as exploitation of the immigration system. While some of these concerns may have legitimate foundations in specific cases, the broad application of these frameworks has resulted in thousands of ordinary Chinese families, including restaurant workers, students, and small business owners, being drawn into the enforcement system. China is included on the expanded travel restrictions, faces the 75-country immigrant visa pause, and has been designated by ICE as a country not cooperating sufficiently on deportations, despite having publicly agreed to accept returnees. If you are a Chinese national in the United States, your risk profile is arguably among the highest on this list. You need a comprehensive legal strategy that takes into account the national security dimensions of the current environment. Ensure that your attorney understands not just immigration law, but also the political context surrounding United States-China relations. And critically, exercise extreme caution about discussing your immigration case on any digital platform that may be subject to monitoring. The expanded USCIS vetting now includes social media and messaging application reviews, and the political sensitivity surrounding China makes any digital footprint potentially consequential. Now let us step back and consider the broader picture, because this is not just about 7 countries. This is about a fundamental change in how the United States treats immigrants from across Asia. Analysis of survey data has found that more than half of all Asian and Pacific Islander adults in the United States, both citizens and non-citizens, report that they or someone in their community has been affected by anti-immigrant policies or sentiment. Nearly half say they feel less safe in this country than they did before. Roughly 30% have experienced or feared arrest, detention, or deportation, and more than a quarter have considered leaving the United States entirely. These figures are sobering, and they are not confined to individuals without documentation. United States citizens, people born on American soil, report being subjected to hostile treatment in public spaces. This is the environment that emerges when enforcement becomes sweeping in scope and public rhetoric becomes dehumanizing. So, what can you do? Here is a 5-step protection plan that applies regardless of which country you are from. Step 1. Know your rights. You have the right to remain silent. You have the right to an attorney. If you are approached by ICE, say this exact sentence: I am exercising my right to remain silent and I would like to speak with my attorney. Then say nothing else. Step 2. Carry an emergency contact card at all times. On that card, write your attorney's name and phone number. The ICE detainee hotline at 866-347-2423, and the IC detainee locator website at locator.ice.gov. If you are detained, your family can use these resources to locate you. Step 3. File a FOIA request for your complete immigration file today. Visit USCIS.gov and submit Form G639. You need to know exactly what is in your file before the government references it in any proceeding. Step 4. Audit your social media thoroughly. Every post, every photograph, every comment. USCIS now reviews social media activity as part of its enhanced vetting protocols. Remove or address anything that could be misinterpreted. Political commentary, images from public gatherings, even casual remarks that could be taken out of context. Step 5. Do not attend any government appointment alone. Whether it is a green card interview, a check-in with a deportation officer, or even a routine biometrics appointment, bring your attorney. ICE agents have been stationed inside USCIS offices since November 2025, and the majority of people taken into custody at those appointments had no criminal record. Here is what we want you to take away from this video. The enforcement climate for Asian immigrants in the United States in 2026 is among the most challenging it has been in decades. Whether you are from Bangladesh, Nepal, Myanmar, Cambodia, Pakistan, Afghanistan, China, or any other country, the landscape has changed. The system that once moved slowly and bureaucratically has become rapid and consequential. But here is the other truth that matters equally. Information and preparation are your most powerful tools. The people who find themselves caught off guard are the ones who did not prepare. Do not let that be you or your family. We want to hear from you. Leave a comment below and tell us which country you are from, and what is the biggest immigration challenge you are facing right now. Your question may become our next video. If you found this helpful, please subscribe, share this with your family and friends, and help us get this information to the people who need it most. We will see you in the next one right here on US Updates Hub. Protect yourself, protect your family. This content is for educational and informational purposes only. It does not constitute legal advice.